This is Duke University.
So I start off with a quote from Philip Roth's short story, Eli the Fanatic, in which a lawyer sends a letter to the principal of the town's yeshiva in which he expresses concern over the appearance in the town of a man dressed all in black, complete with side curls and a black hat. He writes, "This is, after all, the 20th century, and we do not think it too much to ask that the members of our community dress in a manner appropriate to the time and place. In response, the principal replies, 'The suit the gentleman wears is all he's got.' There is no other way in which the man can present himself." Now, I've used that quote in some of my work on Hasidic communities. I didn't know Jane was going to pick that title. I like one of my other titles for one of my articles is The Chutzpah of Hasidism, where I talk about Hasidic communities and how to understand what it means to live in a way that members think of as isolated and parallel, although I try to argue that it actually is not an isolated and parallel life, but in a liberal democracy. And I've also argued that the paradigmatic image of the problematic outsider in the suit that is all she's got is today more apt to be the Muslim woman than the Hasidic man. Now, I start also with that quote because as I left Montreal yesterday morning, there was a story in La Presse, Montreal's newspaper, about Yohanan Lowen, 36-year-old man who has just filed a claim for $1.2 million against two Hasidic schools that he attended, and which are technically illegal, non-compliant with provincial regulations, in Boisbriand, that is just north of Montreal, in the Hasidic Tasher community. The suit is also not only against the schools, but against the Regional School Commission, the Public School Commission, the Director of Youth Protection, and the Quebec government. What's the claim about? Well, he's very upset. He has left his community, unusual, and he argues that he did not benefit from the mandatory free education that is provided for by provincial legislation. He's currently working for very low wages. He had no preparation for the workforce, he says, and feels extremely isolated out of his own community in which he grew up and unable to connect with any other. Now, this is probably not going to turn out to be a claim susceptible to litigation. It's not going to turn up in the Supreme Court of Canada, I don't think. But it's definitely one that caught my attention. Why? Because, of course, usually when we think about freedom of religion, we're thinking about freedom to practice. We're focused on the state's sometimes indirect messages to community when there's some rule regarding an individual member of that community. We would usually worry about someone like Yohanan in terms of his right to send his own children to those same schools to maintain a particular way of life within a community. And here we have kind of a flip side that I also want to suggest introduces three themes or clusters of preoccupation that a quick look at our jurisprudence in Canada will point out. Those are first, institutional autonomy. That is, how do we understand the space claimed by religious institutions? Second, how does religion intersect with family-related questions, and in particular child protection, but also child custody, child education, also divorce. So the family context, a fruitful one for thinking about the intersection of religion and state. And finally, of course, sorry, I just mentioned education, but I was thinking about parental rights, but more broadly, I think on its own, education, thinking about the next generation, to whom do those children belong? Can we integrate our priorities in terms of the child rearing practices and educational perspectives that children, that frame the growing up of Canadian children. Okay, so I'm going to select some sources and stories and themes and finish off with articulating some possible trends or issues right now in the 21st century to pay attention to with respect to religious freedom in Canada. I feel I'm particularly well situated to do so since I participated last week at a roundtable discussion in Toronto on the religion and exercise of public authority, surrounded by, I would say, all of the key scholarly participants in this discussion, with the exception of Charles Taylor, which is why I'm thrilled to, but all people who've worked with Charles Taylor, which is why I'm thrilled to have the opportunity actually to hear from him. It may sound kind of funny to come from McGill all the way to Duke in order to hear Charles Taylor. There we go. Okay. So some of these cross-cutting themes or clusters. I should actually back up for a moment and say that the history of, I'm not going to say history because we've just heard from his kind of historical and sociological context, and I'm not going to pretend to kind of give even a complete history of the intersection of law with religion, but I do want to briefly divide our thinking and experience of state law in Canada and religious freedom claims into pre-charter period and 1982 and beyond. That is, as we've already heard, Canada repatriated its constitution in 1982. That came along with a Charter of Rights and Freedoms. And does that mean that we didn't have issues related to religious freedom of individuals and communities, institutions, education beforehand? No, not at all. There's a rich body of jurisprudence. All of this is so, I feel like it's so superficial, but that's okay. I would say that the key cases fall into reasonable accommodation cases, in fact, in the workplace. So questions of what constitutes a bona fide occupational requirement, perhaps the most famous case, alongside some religious holiday cases and the right to say I can't work on a particular day because I celebrate the Sabbath, for example. But the most famous case, the case of a Sikh Royal Canadian Mounted Police officer arguing that the rule about the uniform, having to wear the particular hat for the Royal Canadian Mounted Police shouldn't apply to him, that he should be able to wear his turban. And so this is pre-charter, right? Pre-charter of rights and freedoms. We have a solid understanding that the image of the Royal Canadian Mounted Police in Canada includes the Sikh man in a turban. We also have litigation through the lens of struggles over federalism, that is, who gets to rule what between the federal government and provincial governments, that had a big impact on Jehovah's Witnesses. So we can trace the thorny relationship, in particular in Quebec, between government and Jehovah's Witnesses through federalism disputes. So, for example, a provincial law banning the distribution of literature, everybody knew what that was about. It was making sure that Jehovah's Witnesses wouldn't pass out pamphlets, that law struck down as outside the jurisdiction of the province. So its consequence, the protection of this particular practice and expression on behalf of Jehovah's Witness community. So it was possible to have attention paid to religious freedom claims even without a Canadian charter, whether through federalism or through human rights codes in particular provinces and at the national level. But the jurisprudence is perhaps probably more interesting, and I will spend the rest of my time talking about the situation under the Canadian Charter, so post-1982. As we've already heard, we have a whole framework for thinking about the protection of religious freedom in the Canadian Charter. Not only the particular section, Section 2A, that specifies the freedom of religion and conscience, but also, as we've heard, Section 15, the equality provision, and indeed some scholars argue that religious freedom has, in the last 30 years, kind of moved in some way from being more focused on individual liberty to being focused on equality and non-discrimination, fairness across fairness in terms of treatment of different religious communities and equal kind of attention and support, combined with multiculturalism as expressed in Section 27. I would also add gender equality as expressed in Section 28. And finally, the first article of the Canadian Charter, Section 1, that is that what may look like an infringement of a freedom can indeed be found constitutional regardless, because it is justified in a free and democratic society. So that kind of combination, and if people want to ask me about how those pieces worked in the following cases afterwards, I'm happy to talk about that. Okay, so if we look very briefly here, I really will just kind of give you the bottom line. This is exactly what I tell my law students I'm not so interested in doing, just looking at bottom lines of cases, but I will do that. So in the context of family, right? Family, schools, children, etc. We have cases that tell us that a parent's religious freedom, for example, even if violated by taking a child who needs medical treatment for a life-threatening disease into care, that is, into the protection of the state against the parent's wishes, that does constitute a preliminary infringement of freedom of religion, but generally upheld under our Section 1 provision, justified in a free and democratic society. Child custody cases, in particular, Jehovah's Witness parents without custody but with access, have been generally allowed to take children door to door, for example, as long as that doesn't slide into harm to the child. We have eliminated, not so long ago, the Lord's Prayer in public elementary schools. We have, the Supreme Court has said that although we have funding for Catholic schools guaranteed by the Canadian Constitution itself, funding for Catholic schools in Ontario, that will not extend to other religious schools, that's a particular deal, if you like, or arrangement set out that doesn't violate the equality claims and religion claims of, in the particular case, Jewish schools. In a case related to Jewish divorce, the get, the woman's, this is anytime I talk about a case that I've actually written on, I cringe at giving you such a kind of one-line takeaway. But the takeaway was that the federal laws, divorce laws, support for equality for women in that context was justified, and that there was no plausible claim of a violation of the freedom of religion for an Orthodox Jewish man who refused to grant the get, the religious divorce. We have, this has not been Supreme Court litigation, but we have moved away from autonomous religious tribunals, other, particularly Sharia tribunals in Ontario. Continues to be a complicated issue. I think, okay, so I'll leave that as a little kind of picture about intersection of state and religion in that context. I think, interestingly, freedom of religion cases around symbols and individual self-presentation, and this will be something I think that actually Charles Taylor will also talk about, so I won't talk about the kind of the Quebec political landscape on this, but instead particular cases. I've already talked about the Sikh turban. That was a pre-charter guarantee. Turbans continue to be an issue, not in terms of whether you're allowed to wear one, but I would say in the context of failing to wear one and being in an accident, for example, failing to wear a helmet, because of a turban, riding a motorcycle, being in an accident, and then asking whether there is some contributory negligence there. So an interesting ongoing issue. A recent Supreme Court of Canada case has said that a niqab wearing Muslim woman giving evidence in a criminal courtroom, being asked to take off the niqab is not necessarily going to be necessary in that context, but the majority of the court seems to think that it's within, or says that it's within the jurisdiction of the presiding judge to indeed, in a particular context, say that no niqab can be worn. The most striking case, the Kirpan case, Maltani, the case of a young Sikh boy in a Montreal school who had actually kind of reached with his own school some agreement about keeping his kirpan safely tucked away, in fact sealed off, and therefore not susceptible to use as a weapon. This went through all levels right up to the Supreme Court of Canada, that indeed guaranteed, with explicit reference to multiculturalism, the right of this young boy to wear his kirpan, a hot case, I suppose, in terms of response to it from his home province. I would say that all of these cases, this kind of whole collection of things, is in some ways, right, all about how Canadian society understands how it gets dressed in the morning, right? What the suit is that Canada has to wear, and also how it thinks about the next generation in particular. No surprise, I think, that many of these cases have to do with children. Finally, I want to talk, though, about explicit public services or institutional kind of autonomy cases. Here we have the Supreme Court saying that the Hutterite community on the prairies in Canada, although it had always had an exemption from photo ID for driver's licenses, the court kind of arguably too easily strikes down that exemption and says there is no violation of religious freedom here. Since the introduction of same-sex marriage across the country, there have been issues of civil marriage commissioners arguing that to officiate at a same-sex marriage would be contrary to their own freedom of religion and conscience. That, I think, will continue to be a hot topic. It has been decided at a lower court level in Saskatchewan that indeed the marriage commissioners generally have to do their job. And finally, another case on its way, I think, to the Supreme Court of Canada at some point, probably dealing with the regulation of the legal profession and the way in which some provincial law societies have argued, even before the opening of a law school at an evangelical university in British Columbia, have argued that graduates from such a law school would not be allowed to be admitted to their provincial law societies. I can talk more about that. Finally, I want to mention a case that we're waiting for from the Supreme Court of Canada, Loyola College, which is a case of a private high school in Quebec. Fascinating case, I think. A Catholic school that asked for an exemption from Quebec's educational mandatory program of ethics and religious culture in the schools. Since the school boards in Quebec moved from Catholic Protestant to English French, not very long ago, at the same time, and therefore dropped religious education within the public schools, Quebec introduced this particular mandatory course, Ethics and Religious Culture, that goes from year to year. And Loyola, interestingly, no religious minority, right? This is a Catholic school arguing that it cannot teach the course as framed by the Ministry of Education in the province, but instead wants to teach its own religious version. And I've characterized, in some of my writing, I've characterized that kind of case as not just a dance between the Supreme Court of Canada and individual claimants, but in fact a tango between the court and religious communities and governance, between state institutional governance and vision of how to think about religion in society, particularly through this course, Ethics and Religious Culture, and on the other hand, a religious, strong religious institution, the Catholic Church and a well-known Catholic school, saying we have our own vision of how to be open to all and how to teach our children. Okay, so I see my time is well over, but let me just take, so I said I would just finish off with what I think are some of the key kind of hot button issues. First, and I, actually some of my Canadian counterparts will be surprised that I haven't mentioned this case, and it was because I was going to spend particular time on it, but I won't do that. One of the key cases has to do with, it's called Absalom, has to do with an Orthodox Jewish man arguing that his signature on a private contract to agree not to put any kind of building onto his balcony in a condo complex should be understood to be subject to his own freedom of religion, and in particular his own sense that he had a religious obligation to build his own sukkah during the holiday of Sukkot in Harvest Festival each fall. And in that case, the Supreme Court of Canada adopts a very individual, personal picture of the importance of religious freedom and points to sincere belief as key to the protection of individuals in their religious practices. So, one key question, looking to the future, what are the differences, if any, between religion and conscience? We haven't had any real development on freedom of conscience, which is also guaranteed by the Canadian Charter. What's special about religion? Is it, in fact, kind of the same as this individual conscience element? Second, how will we work through perceived conflicts between freedom of religion and freedom on the basis of sexual orientation? This, I would have said a few years ago, was all about the kind of conflict about women's equality and freedom of religion that has shifted in some ways in the country to a concern about sexual orientation and equality. Third, how important is all this Supreme Court of Canada stuff for the way in which people actually live their everyday lives and work through their relations to their own institutions? And finally, the relationship between religious freedom and Aboriginal rights. So that just this past week, and I've written an op-ed which is supposed to be coming out in the Ottawa Citizen. Maybe it has today, I'm not sure. Just this past week, we have a case of an 11-year-old Aboriginal child suffering from cancer, a cancer that would have a 95% chance of recovery if treated with chemotherapy. And her mother pulled her out of the chemotherapy. And the Child Welfare Agency refused to intervene here. And a judge just on Friday ruled that she should not be taken into care, not be forced into treatment. Why? Because of the mother's Aboriginal rights. That'll be interesting to watch in terms of the connections, analogies, differences, important differences between Aboriginal rights on one hand and religious freedom on the other. I'm sorry to have
No, it's
gone
okay.
over
Thank
too
you
much.
very much. You came all this way to get.
I want to thank Jane Moss and the Franklin Center for having me. This is a great opportunity. It's always nice to do something that makes you feel like part of the larger university. We've had a lot of litigation about religious accommodations in the last 25 years, and I'm going to try to go into a little bit of detail. Part of the point that I want to make is that the law often constrains us from doing or allowing what we might normatively want to allow, and I think that's true both for secular elites and for religious believers. Nobody really gets everything they want out of American religious liberty law. And the other reason I want to go into some detail is I think that the facts of the cases will give you some sense of the context in which religious liberty claims are arising in the modern era. So we have two religion clauses, right? We have a clause guaranteeing the free exercise of religion, and we have a clause for closing the establishment of religion. And that really gives rise to two questions about accommodations. One question is when is accommodation required? And that means required generally by the free exercise clause, although sometimes by statute. And then the other question is when is accommodation allowed? Because you're doing something special for religious people, and that implicates an establishment clause problem. We've had probably more litigation under the free exercise clause than the establishment clause in this area, but concerns about establishment shape what you can do for people under free exercise. So the governing law under the free exercise clause is stated in a case called Employment Division versus Smith from 1990. So Smith is a member of the Native American Church who wanted to use the drug peyote as part of a religious ritual. Oregon law, though, considered peyote a narcotic, which it is, and his use of peyote got him fired. And because Oregon law prohibits the payment of unemployment benefits to people who've been fired for a violation of the narcotics laws, Smith was out compensation under the state's welfare scheme. So Smith said that the free exercise clause entitled him to an exemption from the narcotics law, but the court rejects that argument. Basically, the court says that neutral and generally applicable laws that only incidentally burden religious exercise are subject only to rational basis review. That's the lowest level of constitutional scrutiny. It's the sort of scrutiny we reserve for claims that do not implicate any significant constitutional right. A lot of people didn't like Smith, especially liberals actually at the time thought Smith was an outrage. It was an opinion by Justice Scalia. It was taken as evidence just confirming what a fascist Justice Scalia was, which makes it a little odd to see Justice Ginsburg taking the same line in the Hobby Lobby case, but we'll get to that. Congress agreed that Smith was an outrage. They thought Smith had got the free exercise clause wrong, and so they passed a statute called the Religious Freedom Restoration Act. The title of the statute makes it pretty clear what Congress is about. The express purpose of the statute is to overrule Smith. They begin with a lot of whereas clauses expressing the purpose of the statute, and it's like, whereas the Supreme Court doesn't really understand the free exercise clause, and whereas we're really better at interpreting in the Constitution than the Supreme Court is, we're going to overrule Smith. And so RFRA says that any government action that burdens religious exercise is going to be subject effectively to strict scrutiny. It has to be justified by a compelling governmental interest, which is the most demanding kind of governmental interest, and it has to be the least restrictive alternative that can further that interest. And Smith is passed with a remarkable political coalition. I think the House was unanimous, which, just think about that for a second in our current politics. And maybe 3 senators voted against. It's just a remarkable, across-the-board, conservatives to liberal, every religious group, even secularists, are all on board in overruling the Smith decision. There are 2 kinds of challenges to the Religious Freedom Restoration Act that then happen. One was based on federalism. So just as in Canada, the law of religious liberty and the law of federalism are intertwined to some extent. As it applies to the states and actions by states and localities, RFRA was justified under Congress's power to enforce the Reconstruction Amendments, the 13th, 14th, and 15th. And so that gives Congress the power to legislate against actions that the states are carrying out that are unconstitutional. But the limit of Congress's power is that what it's regulating has to actually be unconstitutional behavior. And so in City of Burney versus Flores, the court has to consider whether the RFRA is actually going further than the Constitution requires, in which case it would go further than Congress's power to act, at least as against the states. City of Burney is a quite different kind of case, but it shows you another sort of context where this sort of thing arises. So Burney is a town in the hill country in Texas, and it has a beautiful Catholic church, but the Catholic church is a little bit small, and they wanted to expand their sanctuary. Unfortunately, the city of Burney thought the Catholic church was so great and so pretty that they landmarked it, and they wouldn't let the church alter their own sanctuary because that would alter the historical landmark. And so the church says, well, look, that's a burden on our free exercise of religion because we actually can't accommodate our growing congregation, and now the law is preventing us from expanding. This goes up to the Supreme Court, and the Supreme Court holds that RFRA is unconstitutional, that it exceeds Congress's power to enforce the 14th Amendment. And it does this because it prohibits the state or the localities from doing things that the Constitution would not itself prohibit, essentially because the statute goes further than the Free Exercise Clause does under Smith. That means Congress can't enact the statute. So Burney is a case about federalism, but there's a lurking problem of separation of powers, and that is it's really a tug of war over who has the primary authority to interpret the Constitution. Is it Congress or is it the Supreme Court? And not surprisingly, the Supreme Court thinks the answer is us. Right? And so Anthony Kennedy writes the opinion. He cites Marbury versus Madison, where the court says it's emphatically the province and duty of the judiciary to say what the law is, and implicitly not Congress's. Right? And so don't you dare tell us what the Free Exercise Clause means. So that means that the RFRA no longer applies to any action by state and local governments. There you're left with the Free Exercise Clause. For federal activity, though, Congress doesn't need to use its power to enforce the Reconstruction Amendments because it's essentially regulating itself, right? So it can always state the limits on its own activity without using that power, and so RFRA remains in force as to federal activity. That gets us to the Hobby Lobby case. The Affordable Care Act, the National Health Care Statute, mandates that employer-sponsored insurance plans have to provide for preventive care for women's health. And the Department of Health and Human Services, which is empowered to enact regulations under that statute, determines that that mandate includes 20 different forms of contraception, including 4 that operate post-implantation of the embryo. Some religious sects consider this to be a form of abortion because it operates after conception. So if you believe life begins at conception, then this would be an abortive procedure. Other religious groups are against contraception in general and so have a more fundamental objection. So in response to these concerns, the Health and Human Services is actually fairly solicitous. They create broad exceptions to the statute for religious organizations like churches and religious nonprofit organizations, but they refuse to exempt for-profit religious companies. They also exempted all grandfathered employer insurance plans, those that hadn't changed since enactment of the ACA. So if you have an old plan, you wouldn't be covered under this. And all small businesses with less than 50 employees. And these kinds of exemptions are significant because it shows that Congress doesn't seem to think that the structure of the act is going to come crashing down if a few people don't have to comply. The exemptions covered tens of millions of employees. So Hobby Lobby involved 2 separate challenges by businesses that were operated for profit but saw themselves as having a certain religious mission. So one was the Conestoga Wood Specialties, which was run by the Hahn family of devout Mennonites. The other was the Hobby Lobby stores, a much larger business, which was, the court refers to them simply as devout Christians, but they seem to have been connected to the Assemblies of God. So we're talking about a lot of stores, a lot of employees, and massive fines for noncompliance with the contraceptive mandate. All of these companies sue the Department of Health and Human Services to enjoin application of the contraceptive mandate to them. It goes up to the Supreme Court, and the Supreme Court says, in fact, that application of the contraceptive mandate to these plaintiffs is in violation of the Religious Freedom Restoration Act. There's really three critical issues in the case that all are significant for future litigation. One has to do with whether corporations can sue under the Religious Freedom Restoration Act if they're for-profit corporations. And the majority basically made three important arguments. One is, textually, the case is governed by something called the Dictionary Act, which says all federal statutes, when they use the word person, that includes corporate persons unless Congress expresses some intent to the contrary, which Congress hadn't done here. The second point is that logically it's hard to draw the line that the government wanted to draw between nonprofit corporations and for-profit corporations. So the court, it had always been clear that the free exercise clause, for instance, applied to corporations. Many churches are corporations. They have free exercise rights, for instance. So that can't be the line, that it's just corporations are out entirely. It had also been clear from the Supreme Court's jurisprudence that for-profit businesses, in fact, sole proprietorships, for instance, had religious free exercise rights. So there are cases, for instance, about Jewish businesses challenging Sunday closing laws. And nobody says that you don't have standing to challenge this as a matter of free exercise simply because you're operating your business for a profit. So you have to figure out, well, why would it make any difference that it's a for-profit corporation when both for-profit entities and corporate entities are covered? The more fundamental point, though, that the court makes is that nobody is saying that corporations worship God, that corporations can go to heaven. Corporations are simply a legal instrument by which people operate collectively to enforce their rights. Right? So there are cases about the NAACP, for instance, as a corporate vehicle for people to assert their free speech rights. It's more effective to assert your free speech rights in a group sometimes than it is individually. And this is the same situation. There are circumstances in which people want to do a particular thing religiously, and they need the corporate form in order to do that. These are businesses that have undertaken a fairly novel experiment, which is to determine whether a large business can be conducted on Christian principles, closing on Sunday and treating their employers in accordance with Scripture and things like that. And that is a form of religious free exercise, the court says. So that's the first issue. The second issue is there a burden on the free exercise by asking these employers to help fund the provision of these contraception devices to their employees? After all, nobody's asking the owners of the businesses to use these contraceptives, right? They're simply being asked to fund. And this is, I think, is the hardest issue in the case, because the employers say, well, look, we are being implicated in the commission of a sin. Right? We are facilitating the commission of a sin by others, and as a matter of our religious doctrine, that implicates us in the sin. We shouldn't have to do that. And the dissent in the case effectively said, this really isn't much of a burden. Right? It's minimal. It shouldn't be considered to even implicate the free exercise clause. And the tough thing is, we can have a debate about whether it's a reasonable belief to think that if you simply contribute to the provision of insurance company coverage for a practice, that you're involved in the sin that you think that practice implicates. What the majority says, though, is we can't really get into that. Right? We can't assess whether this is a reasonable religious beliefs, because if we go down the road of asking which religious beliefs are reasonable, then that's going to unwind the free exercise clause altogether. I love teaching religious liberty because we get to talk about snake handling and faith healing, all crazy things, right? And so if we ask, are these reasonable religious beliefs, then that, I think, is an end to religious liberty. On the other hand, it's hard to run a doctrine that expressly doesn't care whether people are being reasonable, right? I mean, how can you have reasonable accommodation if people don't have to be reasonable, right? And this is going to come back, I think, to haunt the court in the cases that are coming to it going forward. The last issue that the court has to decide is whether the government is imposing the least restrictive alternative, right? The court is willing to accept that the interest in providing women with contraception is a compelling interest, right? So there's no debate about that. But they say, look, even if that's true, this wouldn't be the least restrictive alternative to further that interest, because look, you've already included in the statute a less restrictive alternative, which is the exemption that you've already granted to nonprofit corporations, right? So if you think that's feasible for nonprofit corporations generally, then there's no reason to think that it wouldn't be feasible also for this very limited class of for-profit corporations that want the same treatment. And so having already demonstrated that the alternative could work, it's very difficult for the government to answer the argument that that isn't available here. So I think actually, despite all the Sturm and Drang about Hobby Lobby, it's a fairly easy case on the law. Right? This is not, the way it's been presented as a clash between the rights of religious exercise on the one hand and contraceptive choice on the other hand. But nobody's prohibiting the use of these contraceptives, right? And even if you thought that there was a positive right to have the government provide these contraceptives, that's not being foreclosed here either, right? The question is whether the government can make somebody else pay for these contraceptives for you, right? One alternative is always for the government to simply provide them directly, right? So I think it's hard to say that this is a straight-up clash between reproductive liberty and religious liberty. The burden question, I think, is hard, but it's difficult to go the other way without reconsidering the idea that we're not going to assess the reasonableness of religious belief. And that leaves you just with the third way that RFRA is hard, and that's simply that a lot of people, I think, have now changed their mind about whether RFRA was a good idea in the first place. And it is an extreme statute. It imposes a very high standard for government actions that burden religious liberty. That's what the statute says. That's what Congress clearly had in mind. If the court doesn't like it, they need to urge Congress to repeal it, I think. So we have some hard issues coming, though. There are follow-on cases to Hobby Lobby. A good example is the Little Sisters of the Poor case, which everyone loves because of the name, coming up out of the 10th Circuit. So in that case, this is a religious group that operates nursing homes for the elderly. They're covered by the nonprofit exemption. But they say that in order to get the accommodation for nonprofits, we have to fill out a form. And that form triggers insurance coverage for these contraceptives. And we think even filling out that form implicates us in the provision of these contraceptives that we think are abortifacients and therefore sinful. So even that, even though we're not being required to pay for it, we are being required to participate in a process that ends in the provision of these contraceptives to people, and we think we shouldn't have to do that. I think this really puts the question of, do you have to be reasonable at all in a very stark way? Because I think it's very difficult for most observers to think anything other than, give us a break, you already won, right? I mean, accept the victory gracefully and go on. And so I think the court's going to have to decide whether there's any kind of threshold reasonableness requirement at all. There's already a split in the circuits about whether claimants in these cases are entitled to a preliminary injunction. That suggests we're shortly going to get dissent or a split in the circuits on the merits in these cases. So I think we'll see Supreme Court review, if not this term, probably in the next term. We have another case that the Supreme Court has already heard argument in. It's not a Hobby Lobby type case. It's a case under the follow-on statute to RFRA, and that is the Religious Land Use and Institutionalized Persons Act, the RLUPA. One thing that our lupus shows is the breakdown in the political coalition that had supported the Religious Freedom Restoration Act. Because after the Supreme Court strikes down the RFRA as to the states, Congress tries to reenact it, and they try to fix it in various ways. But by then the politics have changed, and all of a sudden there is not this extremely broad coalition in favor of a statute. Instead, you have liberal groups largely jumping off the train basically over the issue of gay rights. Right? The concern is that broad exemptions from federal law or from state laws will undermine the enforcement of public accommodations laws that protect gay people from discrimination, for instance. And so the coalition was there only to enact a law that regulated burdens on religion in the context of zoning and in the context of prison worship. It's just the oddest combination of things that you're likely to see in a statute. So Holt v. Hobbs is an Arlupa case out of Arkansas where a Muslim prisoner wants to have a beard. And the state says, no, that poses a security risk. You might hide stuff in your beard or something like that, and so we shouldn't have to let you have a beard. I think we got a clue about how that case is going to come out at oral argument when Justice Alito asks the governor or the lawyer for the state of Arkansas, he said, well, if you're worried about them hiding stuff in the beard, can't you just make them comb through it once in a while? And if they're hiding like a cell phone SIM card or a tiny revolver falls out, then you can confiscate it, right? And so if Justice Alito is making jokes about your claim as a prisoner, it's not looking good for the state here. So that's going to be 9-0, I suspect. A third class of cases that are coming are about these state exemptions from state public accommodations laws, particularly those that protect gay rights. So Elaine photography is a good example of that, decided by the New Mexico Supreme Court. Do you have to photograph a same-sex wedding if you object to same-sex marriage on religious grounds? And the New Mexico Supreme Court said you did. Rejecting a claim under the Free Exercise Clause, rejecting a claim under the state-level Religious Freedom Restoration Act. Now, this doesn't implicate the federal Religious Freedom Restoration Act because it doesn't apply to state action anymore. That means it has to go forward under the Free Exercise Clause itself, under the Smith rule, which is that neutral and generally applicable laws simply don't raise a freedom of religion problem. I think the court is likely to say that anti-discrimination statutes of this kind are neutral and generally applicable laws, which means there's no viable free exercise of religion claim. The interesting things about these claims, though, is a lot of the people who are challenging the public accommodations laws are engaged in activity that is expressive under the First Amendment free speech clause. So photographing a wedding, maybe even creating an amazing wedding cake for a wedding, that all may be expressive conduct. And so if you're compelling people to engage in expressive conduct contrary to their religious beliefs, that may raise a speech clause claim. So I think these issues in the federal courts are going to be decided that way. At the state level, they're going to be decided under the state's own Religious Freedom Restoration Act, and we're likely to get a patchwork of results. So let me just make three final points by way of concluding. One is, the most difficult questions now, like the Hobby Lobby case, I think are arising because of a change in the role of government since the founding. When the government doesn't do very much, there's not much need for accommodation from government practice. If it's not regulating very much, you don't need many religious exemptions. So one of the reasons why we're seeing so much more of this and why the founders didn't think about accommodations that much is because government does so much more. The second thing is, I think these cases are arising out of a broadening range of religious traditions that have to be accommodated. So most of the religious debates in the early republic are among different Protestant sects. And one of the offshoots of that is you get a conception of the free exercise of religion that's incredibly individualist. It's all about the freedom of individual conscience. Right? That's not necessarily how Catholics or certain Jewish sects or Muslims or any number of other people think about religion. And I think we have to be careful to make sure that our view of free exercise doesn't establish a Protestant conception of what religious exercise means. And then the third thing is there's been a fundamental change in the nature of religious controversy. It used to be one religion versus another. So it was the Anglicans versus the Baptists in Virginia. It was the Protestants versus the Catholics at the end of the 19th century, early 20th century. It was everybody versus the Mormons at the end of the 19th century. Now I think the debate is mostly religious people on one side and secularists on the other. Right? So the Baptists and the Catholics have finally gotten together, for instance. And that, I think, has the potential to be a lot nastier because religious belief is becoming the primary predictor of partisan identification. And so when fights over religion map onto partisan fights among the parties, we're likely to see a nastier religious climate. That's it.
Thank you. I must say, I'm absolutely stunned by the brilliance of both of those presentations, and I'm going to let you comment, but I'm actually going to propose that we maybe go right to Charles Taylor, because a lot of the issues that you both raised really will be discussed by you, that sort of the individual versus the group, the sort of common social values. So if that's all right with everybody, and if you need to get up and go, just do that. But I'll let Shauna have a word, and then.
I don't want to have a word if everybody is waiting for you to talk.
Well, just a response, a quick response.
Well, a couple of things. I thought that it's interesting. The Absalom case that I mentioned about the sukkah is exactly one of these cases where the claimant has to make a claim about religious freedom that is not how his own community would understand religious freedom. And this is very interesting and tied to this idea that if the core of the protection is about a highly individual kind of sincere belief that that's going to be the thing that you have to prove, whereas many people would say in a religious community that no one goes and checks what each person has in his or her head, heart, soul, etc. And I totally understand the idea that government does it more and more, although I can't understand how government would push anybody to take photos or make wedding cakes. I'm a little, I find that really interesting because of the intersection, actually, with the hat that I wear in my teaching, which is private law, right? Mm-hmm. So like if you contract to take photographs, ostensibly you see the names of the people who are getting married. You don't actually have to give your reason, so that's interesting. Well, I guess I mentioned this dance metaphor, and here I'll hand this over to Charles because I just wrote a short essay saying that what goes on in Quebec is like, not like a ballroom dance or a tango, but dancing the hora. We just go round and round and round. All right.